Hello and welcome to my YouTube channel. Have you ever wondered whether both Central GST officers and State GST officers can show up and ask questions and can both demand GST? Today's landmark Supreme Court ruling in the case of Armour Security clears up this confusion once and for all. Before we take up the case, please appreciate that GST law has two enforcement modes. First, single interface, and second, cross empowerment. Single interface means one taxpayer should deal with only one tax authority for routine matters like registration, returns, audit, etc. On the other hand, cross empowerment means both central and state authorities can take intelligence-based enforcement actions across the entire value chain. And Clause B of subsection 2 of section 6 of CGST Act says that once formal proceedings starts, the other authority cannot start the proceedings on the same subject matter. That means if Central GST authority has started a formal proceeding against you, then State GST officer cannot proceed against you on the same subject matter. So this case clears up as to what do you mean by formal proceedings and what do you mean by same subject matter. Let me tell you what happened in this case that reached Honorable Supreme Court. In November 2024, State GST Authority issued a show cause notice to this party for alleged excess input tax credit claim. In January 2025, Central GST officers conducts a search and issue summons under Section 70 to this same party. The company argued, how can two different GST authorities or GST departments can investigate against me on the same subject matter? This is exactly what Section 62B is supposed to prevent. So the first question before the apex court was, what constitutes formal proceedings? Search, summon, show cause notice. What do you mean by formal proceedings? Honorable Supreme Court ruled that summons under Section 70, searches under Section 67, these are investigative in nature, not proceedings. Show cause notice under Section 73-74, adjudication, demand orders, that is where liability is fixed and they constitute proceedings. Think of it like this. Summons is like a police inquiry, but proceedings start when a charge sheet is officially filed. For example, a show cause notice is issued. Next, let's answer what is meant by same subject matter. The court devised a twofold test. First, same facts and identical tax liability being examined. Example, same period, same credit claim. Second, same demand or relief being sought. Example, identical amount in show cause notices. Please note that different periods or different infractions remain outside the bar of Section 6. This case has settled that. Clause B of subsection 2 of Section 6, bar applies only when show cause notices are being issued for same tax liability, and this is not applicable for preliminary inquiry or summons. Proceedings must seek to recover or demand identical or overlapping tax liability. In this case, Honorable Supreme Court further established certain principles. First, difference between intelligence-based and audit-based actions. Audit-based actions must be done by assigned tax authority only. Intelligence-based action, on the other hand, can be undertaken by Central GST Authority or State GST Authority. It doesn't matter. Furthermore, apex court issued certain guidelines. Taxpayers must inform the authorities about parallel investigation. Authorities must communicate with each other. Authority which initiated formal proceeding first should continue with it, and there should be no transfer of cases through administrative orders. So what this means for taxpayers and tax professionals: multiple summons are allowed. You may receive summons from both central and state authorities for different aspects of your business. However, only one authority can issue you a show cause notice on specific grounds, and the other authority would be barred from issuing you a show cause notice for the same liability. Thirdly, cooperation between taxpayer and authority and between both the authorities is quite necessary. But most importantly, the takeaway from this judgment is that if you are facing duplicate proceedings, you now have a relief. If not right before the authority, you can even approach your jurisdictional high court under Article 226 of the Constitution of India, that is the writ jurisdiction, citing this apex court ruling. That's it for this video. If this helped, please like the video, share it, subscribe to the channel if you haven't already for more such videos. I'll see you in the next one. Till then, take care. Have a good day. Bye-bye.